students will have a, if they want to check it out. All right, great. So let me jump in here and do the screen share. All right. So let's do a screen share. And before we discuss today's case, which is the Barbie case, the Mattel versus MCA Records, let's see here. I did want to bring to your attention this Harvard Crimson article. I don't want it to get lost in the shuffle. And here it is, the first ever article about Facebook. It's in the published in the Harvard Crimson, and you can see it's a different writer. It was Barry Schwartz who wrote the first article about Face Mash, and now we have Alex Tabak writing an article, a few weeks later about the launching of Facebook. And this is a really interesting article. I don't want to put anyone on the spot, but I do want to ask if anybody, had a chance to look at the article, what jumped out at this is, if anybody wants to jump in and unmute. I don't want to put anyone on the spot. I should have made it more clear, please read the article. One of the things I love about the article is that, we take Facebook, and Google and all these amazing Apple, all Amazon, all of these amazing services and products and platforms for granted today, but imagine what the world would be like without them. Now, maybe the world would be a lot better place without Facebook, frankly, and Instagram and all that and all this stuff going on. But, it is frankly, I don't know if I can say the same thing about, not having Google search or not having Amazon. Maybe there'd be other substitutes, that would have jumped in, and provided similar quality services and those kind of things. But, we take all of this big tech stuff for granted. And there's a second question there that we won't deal with today. Do we need to break up big tech? We'll do this at the end of the semester, deal with some current issues, in fact, there are some current lawsuits right now, antitrust lawsuits against Facebook and against Google. And I'm not sure, now that we have, a new president and a new leadership at the Department of Justice, it's not clear to me, if these lawsuits are going to be withdrawn or somehow, these cases are going to be, put on the back burner. But for the time being, both Google and Facebook are being sued. And that's something we're going to discuss in that last module on civil and criminal cases. We'll take a look at those antitrust cases. But here what I want to do is go back to the founding, the internet era, when the internet was just a few, 100 days old. By the time Facebook is launched, internet is only about 3,000 days old. And by this, I mean the commercial internet. There was something called the ARPANET. I've blogged about this. The ARPANET was the, if you will, the precursor to the public internet we have today. The ARPANET is what connected some highly, sensitive military installations like Los Alamos laboratory in it's close to Santa Fe, New Mexico, and the Livermore labs in Berkeley, California, and of course the Pentagon and it's MIT. All of these top places doing classified military research, maybe on UFOs. I don't know, but the point is that eventually became open up to everybody. We have the internet we have today. And I just want to, what I like about this article, I'm going to be honest with you, is just describing this thing that was just, launched from a student's dorm room. And this new platform, and I showed you in the previous class, the homepage of the original Facebook as Harvard students would have seen it back in February of 2004. This would go on to really be this giant internet empire, for good or bad. I want to put aside that normative question till the end of the course. Is this good or bad? I think arguments can be made perhaps on both, definitely on both sides. But here, but this article, right, is describing something that is just going to take off remarkably quickly and end up, again, for good or bad, end up changing people's lives. And that's really, really remarkable. Really, really remarkable. Well, what I find there, the deeper lesson is, we don't realize this. We take all of these products and services for granted. But products and services have to be provided generally by business firms. Even the government, when the government nowadays wants to provide a good or service, generally speaking, the government will put out bids. There'll be a contracting system. It'll be a private company working through the government, providing those goods and services, again, for good or bad, what should be the role of government? How much services should the government finance? Those are separate sort of normative questions, but just I want to describe the reality we live today. And so business firms are really, really important. And what's really fascinating about Facebook and then the movie, The Social Network, that, purports to describe the founding of Facebook, is that it was started by college students. And I don't want us to lose sight of that, and this article is really interesting because you can take a look at it for yourself, but there are lots of students are being interviewed and quoted for this article, and including starting with Mark Zuckerberg, let's see here. I may have gone down. There's also Kevin S. Davis is quoted here, the director of residential computing, who we've seen before with the whole face mash. As I described, as I explained in a previous class, Kevin S. Davis was the one who ad boarded Zuckerberg, and so he's in here because, Harvard was supposed to develop a universal house Facebook, right, for all of the houses, all of the residential, houses at Harvard. Up to this time, Harvard, each of these houses were in, because of Harvard's history and tradition, they are separately, basically autonomous units within Harvard University. And so they each had their own separate Facebook, not a universal Harvard Facebook, right? That was electronic. There was, by the way, a physical published version, but not a, electronic. So Zuckerberg comes in and shows you sometimes the advantages entrepreneurs have. Harvard is this big, even though it's a private institution, right? But it's, it has a lot of tradition. It's like UCF, a bureaucracy. You got to get a lot of permission. And here, Kevin Davis is now once again on the defensive. First, he's on the defensive because a sophomore hacked into the database and, got a bunch of pictures and stuff like that. Now he's on the defensive because it's been 2 years later. People are talking about this, and Harvard still has yet to develop a universal Facebook. So there's a quote by Davis saying that this is a high priority, but of course, right, that's BS, right? Because if it were a high priority, it would have been done by now, right? And Zuckerberg has already done it. One of the interesting things that I find personally, and from a legal perspective, interesting about this article that actually captured my attention is that here in this first quote where Zuckerberg is quoted, he's interviewed for the article. And let me tell you too, it was Zuckerberg, a Facebook co-founder, my understanding, Chris Hughes from Hickory, North Carolina. I don't know if we have any North Carolinians in the house, anybody associated with the great state of North Carolina. But he was, I think he was, I don't know if he was on the Harvard Crimson or had a lot of friends on the Harvard Crimson, and he was really indispensable in helping get setting up his interviews and getting this, if you will, this free publicity. You know what I mean? But what I like about this from a legal perspective is I see Zuckerberg kind of trying to create an alibi, in the event that he is sued by the Winklevoss twins, or in the event, he's ad boarded a second time, which would lead to his automatic expulsion, and that is, you see here that there's a quote, that everyone's been talking about a universal Facebook, right, for Harvard. And, it's kind of silly, no one's done it. And then he says, I can do it. And I did it in about a week. Remember the launching, you can look at this article dated February 9th. The website went live on February 4th. So if we're talking about a week, January has 31 days. So we're talking about, he's saying that he started the coding for this project, on, at the earliest January 27th, you know what I mean? 28th, that would be the 1 week period, 1 week, if we're going to define that as 7 days, and in, real life, what we know from the litigation and from the movie, which is based on the allegations and the complaint and the deposition testimony, that Zuckerberg, right, it's around the middle of January, two critical events happen, right? First, Zuckerberg, that we know for a fact, first Zuckerberg registers the domain name for the Facebook.com or www.thefacebook.com on Network Solutions on January 11th. And then a few days later is when there's this assessment that Zuckerberg shares with the Winklevoss twins, that their Harvard Connection website, which I've shown you before. And I think I've posted a link to it, a screenshot on the Wayback Machine in the module, that it was not functional. You know what I mean? So the idea is that Zuckerberg, I say this, is creating an alibi because, it's not until after, regardless of the dates of these events, it's not until after he begins coding for the Facebook. So 2 points here, right? One is an issue of credibility. Do we believe Mark Zuckerberg, right? Do we believe this is the same guy who told a member of Congress that Face Mash was a prank website? If you believe that, if you accept that description, maybe you're more likely to believe Zuckerberg's alibi here. If you think Zuckerberg is full of it, you probably, when he was testifying in Congress, probably you're not going to buy the alibi here. What's really interesting, this kind of things you learn in law school and like what's called trial tactics or trial techniques. It's a lot like chess at the highest levels. Like I'm watching the Meltwater Chess Championships right now. I think it's day 5. I was watching the quarterfinals, Magnus Carlsen, Aaron Levanson yesterday. In chess, it's so amazing because they grandmasters can set traps, and it's just well, that's what they do in litigation. Like if I'm the Winklevoss twins, right? I'll use this alibi, even assuming it's true. I can still use it against Mark Zuckerberg, right? By saying, well, yeah, the reason why it took you a week was because you saw our source code. You know what I mean? You saw our source code. And so whether it's true or not, you didn't use any of our source code, in the Facebook, the reality is you saw our source code, you kind of saw our trade secrets, you saw, a lot of the shortcuts, what steps need to be taken to create a social network. And so that's why you're able to get that advantage, and do this in such a short period of time, even assuming that's true. The truth, of course, is that you were working, on your website, while you were pretending to work on ours. But even if that's not true, I can still use that alibi against you. So, and there's a whole bunch of other information in here. The other thing I'll mention, probably the last thing I'll mention here, unless anybody wants to jump in about this article, but the other thing I found really interesting in here, and this is where, this is one of the reasons why I find the movie to be highly credible. Oh, by the way, here you can see some this one student, Roberto Acosta. He's interviewed, right, as to why he is signed up for the Facebook. The other article doesn't mention it, but it's really important. It is in the movie. And this is where I think the movie is good. There's 2 points I'll mention here. One is Eduardo Saverin, one of his key contributions to the Facebook, in the founding phase, is not the $1,000 that he chips in and then later he ponies in a whole bunch of more money, but more than the money that he pinches it, that he throws in there and invests, which is a big contribution. I don't want to belittle it, from a college, from a college business, what would you do with $20,000, $21,000, whatever it is that he ultimately invested early on? It's a lot of money. But more than that, Eduardo, and this is what I like about the movie, Eduardo is the one who gives Zuckerberg the listserv or the email addresses for everyone in I think it's the club that he's trying to punch. I think it's called the Fox, or I forgot the name of the actual club. It's one of these finals clubs. And you have to understand that this is a really big deal because from Eduardo's perspective, he's been punched. That is to say, he's been invited to pledge or to, go through the initiation ritual to join this very prestigious social club, right? And that would make a huge, think about your own personal lives during the pandemic, how it basically sucks. You can't really hang out with anybody. It's tough, though thankfully, I would say thankfully Florida, has been a little bit less hardcore than in some of the other states. But the thing is about it is, imagine how that would change your life. You get to join one of these finals clubs. You automatically, your social life, you automatically, you're going to be, it's a whole different college experience, And so Eduardo kind of jeopardizes all of that by saying, even though I'm in the process of, wanting to get selected to join this club, and I've already made that initial cut, I'm going to share with you the email list. And I say that's a big contribution because think about it. We don't know how people are going to react to the Facebook. I mean, it turned out, as we now know, right, that everybody loved it, and as you can see from the article, already several hundred students had already joined the Facebook. You know what I mean? And that's just in the first few days that it went live. And I would argue a big part of that was, well, the largest part was that Zuckerberg put out a nice website that was clean and simple and allowed you to connect with your friends, regardless of what residential house they lived in, right? But the other reason why is that Zuckerberg, right, instead of just emailing it to a small group of people, he was able to email it to people who were already part of one of these finals clubs. The Phoenix, it was called the Phoenix, that's right. The Phoenix. And so, that also helped because then you have the right people joining, people who are already well connected, people who are already part of a finals club. And so therefore, by definition, they're well connected. You know what I mean? Because they've gone through, they've been vetted. And ultimately that helped Eduardo get, join the club, but at the time, it's kind of a risk, right? Well, what if these people think it's a spam and they don't like Zuckerberg's website, and then it blows up in my face. So I wanted to throw that out there. The last thing that I really caught my attention in this article is this one more quote by Mr. Zuckerberg in here. And Zuckerberg says something about, talks about privacy. He talks about privacy a lot, and that here with, he learned his lesson from FaceMash, and that here with this new website, you'll be able to establish your own privacy setting, And so I find that really interesting because, privacy, that's the big issue today. Like to the extent people don't like big tech, you know what I'm saying? And to the extent, one of the reasons the government is coming after big tech on the antitrust side is because of the lack of, let's say, privacy protections of our data. It's one of the big problems with big tech. Even those who are fans of big tech, have to concede that this is a really big problem. What should we do about people's privacy? And this is the reasons why Zuckerberg was called to testify in Congress in the first place. It was because of the Cambridge Analytica data breach and all kinds of stuff. So it's like, to what extent has big tech gotten their act together about protecting our privacy? Even if our privacy is protected at a satisfactory level, you know what I mean? And you have the choice of, your privacy settings on certain websites like Facebook and Instagram. That doesn't stop these companies, right, from using your data, right, and selling it to third-party advertisers. That's how they make their money, in fact, And so most people probably are okay with it. Who cares? You know what I'm saying? But a lot of people are not okay with it. And that's something that we'll discuss, like I said, in that last module. And those are live issues. How should the courts, how should the law, how should the Congress respond to that? I just want to throw it out there that you already see those key issues already being discussed in this early article. But I don't want to detract from this great achievement because, who wouldn't want to be someone? I think it's a great thing, as for all of his faults, we could point out and nitpick, right? Zuckerberg is the billionaire. It's not me. It's none of us here. You know what I'm saying? So I always have to take my hat off and show, wow, I'm just respect, respect that a young college student was able to create this great thing and take it as far as he did, as he has, because it's still in the present. Are there issues? Are there problems? Of course. Nothing is perfect. And we will discuss that in the remainder of the class, but the remainder of the semester. But I do want to also be fair, right? Fair and balanced, like they say, and show the positive side. All right. With that, why don't we discuss our case here? Anyone want to jump in? Anything else in the article that is in there? A lot of discussions, like I said, a lot of things. One of the things I'll mention here that I find very interesting, let's see here, is Zuckerberg. There's this quote. The movie makes a big deal out of this. It comes from this part of the article. This, what I've highlighted here on the screen share, it's basically Mark Zuckerberg giving a big middle finger to the Winklevi, because here he's saying he hopes now that he's created this new website with some intense privacy options, as he is quoted as saying, he hopes this will help rehabilitate his reputation, right? And that was the whole purpose of the Winklevoss twins reaching out to him, saying, why don't you work on our website? And then, if our website becomes popular, what a great way to rehabilitate your reputation, right? And the movie dramatizes that, you know? We don't know what words were really exchanged between the Winklevoss twins and the Zuckerberg, right? It's all deposition testimony. It's all levels of credibility, right? But you can see it's right there, and then the Harvard Crimson, right? So it's like there must be some kernel of truth to that, to that particular issue. All right, let's end the screen share here, and what I want to do is bring that historical artifact, that Harvard Crimson article, to everyone's attention. You know, it really is worth reading. Now we have this case, this Mattel case, and I've the screenshot I've given you, or the what I've included, it's just the synopsis, not with the court decision. The facts are fairly straightforward. I want to share with you, though, a couple of things that are not in the synopsis that are in our textbook. We were listening to the Barbie song at the beginning of the video. It may not, it may be cut off on the recording for those students who watch it via recording. But there's this famous, Barbie girl song by I think it's a Scandinavian group called Aqua, and one hit wonder, but a great song. And then, Mattel, that's invested, and they've owned the intellectual property rights too. They didn't create a Barbie doll, but they bought the rights from this lady. I believe her name is Ruth Hellenberg, if I'm not mistaken, who created the Barbie doll. One of the things I learned from the exhibition, actually from the Barbie Museum that's in the Czech Republic in the city of Prague, is that before Barbie, dolls were, much more traditional and girl-like. Barbie, what was innovative about Barbie, it's the first, and now you have this LOL and Bratz and all these other dolls that are, I would argue, very controversial, hypersexualized. But Barbie is the first, if you will, doll for girls that's not a baby, it's a grown woman, and it just took off in a huge way. One of the things, though, is that Mattel, they bought the rights to Barbie, and then they later created the Ken doll, and they later created, so many different versions of Barbies, and it obviously is their best-selling product. Along comes, why would they sue Aqua? This is the first question here. Just a strategic question, right? I mean, couldn't you make the case that this song, which was a number one top 10 hit, Billboard, not just in the United States, but in Europe and all the world, why sue? Why sue? You're getting all this attention, right? Presumably, isn't this helping you expand your markets, and expand the reach, of Barbie? Why would they sue? Why would they sue? And by the way, they sue MCA Records, not Aqua, the band, because MCA, the recording industry. Now it's starting to change. A lot of new artists, I understand, are starting to do their own record labels. I think Jay-Z is became very famous doing this. But back in the day, if you wanted to be a big time musician, you would have to sign up with a major record label, and the record label would have the money to then, do the marketing, get you on, get your, get the word out, and buy the airtime for radio play, et cetera, et cetera. So why sue? Anybody want to jump in here? Sort of a strategic question, right? Sometimes why sue? Why bring a lawsuit that's going to cost you time and money, even if you're going to win? And by the way, if I could do a timeout, this is my favorite part of the and I love The Social Network, as you can tell. I've seen this movie. I've read the screenplay. I've read the book. All of this, on which it's based, multiple times. And still, my favorite line from the movie is when Justin Timberlake, playing the role of Sean Parker, tells Eduardo Saverin, played by Andrew Garfield, "You want to buy Tower Records, Eduardo?" This is that scene when Sean Parker meets Zuckerberg, and this did actually happen in real life. Sean Parker saw the Facebook, was at Stanford. Wow, he thought this was the best, website he's ever seen. You saw what the internet looked like. It's in the module, right? It was a nice and clean and simple website, bringing together college students at these top 4 colleges at that time, Yale, Harvard, Columbia, and Stanford. And so he flies out to meet Mark Zuckerberg. And Mark brings Eduardo, and then, in the movie version, Justin Timberlake is bragging about how he, vanquished the recording industry. And Eduardo, who's already pissed off about the whole thing because he realizes that, Jesse Eisenberg, the Mark Zuckerberg really looks up to Sean Parker, kind of like driving a wedge in their friendship. He says, snide remark to Sean Parker, Justin Timberlake, hey, but you lost the lawsuit. I mean, the recording industry, we saw this in the last time, right? They shut you down, right? There was an injunction, and you were no longer allowed to engage in peer-to-peer file sharing of copyrighted files, right? And so, and that's when Justin Timberlake says this great line about, you want to buy Tower Records? Yeah. The recording industry, the record industry, right? They did win the lawsuit, but they lost the war. Nobody buys CDs, or very few people buy CDs. There's a niche market for some vinyl, LPs, record albums, but most people do via streaming, to the extent that they get their music commercially that way. All right, so why sue? This is really the key question here. Anybody have any thoughts about this? Yeah, Nani, jump in here.
Okay, so Mattel through Barbie has done a lot. My granddaughter's into the Barbie show and has watched a ton of it. Barbie had 130 something different careers through the various collections that were released, and a lot of those were very STEM based. She was a veterinarian, she was an astronaut, she was a physician. So Mattel really tried to bring those male dominated professions into the realm of little girls. And by doing that, it opened up children, mainly girls' eyes to the fact that they can be some of these different things as far as their occupations and professions. And when this song came out, our family loves the song. We like to sing along with it, but it just paints Barbie as this party girl and, does absolutely nothing to promote a positive image of Barbie. It makes her into a bimbo. And, I can see why Mattel would not want this song out there and want people associating their product, which was all about empowering and educating young girls, to be associated with this, brainless party girl.
This is one of the great ironies of this lawsuit. That's exactly right, by the way. It's all about Barbie's image. It's one of the great ironies because that's always been the feminist critique of Barbie, her measurements, the unrealistic expectations, this and that. So Barbie and Mattel, in fact, sensitive. See, Mattel's in a real tough spot, right? I have no, either we want to believe that Mattel's executives are really bad people, inflicting enormous damage to young girls everywhere, or that, they have kids too, they have daughters too, and, but they have this best-selling product. What do you do? What do you do? And so Mattel, they had this ingenious, probably one of the most ingenious business strategies in the history of modern capitalism. I mean, that's what we're talking about here. Well, let's turn Barbie into a doctor, into an astronaut, into an engineer. And that's exactly right. So Mattel invested so much in their number one best-selling toy product, right? And they also did a lot to try to change that image. Now, it's still, like they say in Puerto Rico, where I lived and taught for many years, it's another $20 whether making a STEM Barbie, doing all this image reconstruction still responds to the feminist critique. You can argue at both sides. But my point is that this is exactly why, Mattel decides, we're going to have to take legal action here, and this happens to me a lot. Like I remember one time, when the pandemic started about a year ago. I remember when Adam Silver, canceled the NBA season, suspended it. And I remember, like a weekend or maybe 10 days. And this is when the lockdown, even in Florida, was a real thing, like you couldn't, go anywhere, before they did the phase 1 reopening and the first week of May. And I remember my wife and I, we were just going crazy. Said, let's get out of the house, even though we just drive around. And so we did. And then I listened to the radio for the first time, Blueberry Faygo, which is great hip hop. I really love that song. It's so catchy. And then when I went to, or this happened to me in January, even more recently, I listened to Ariana Grande's 34 plus 35 song, which is I love that song. Then when I go to listen to the lyrics, because I always say, well, I want my, I want my daughters, my kids to listen to the song. I go, oh my God, this is some horrible stuff. This is a great song, melody wise, but when you read the lyrics, it's some horrible stuff. And you got to go back to the mid 1990s when society was a lot more conservative than it was today. Because there was no Facebook, there was no Kim Kardashian, there was none of this stuff that we have today. I mean, yes, sex always sells, this and that, but it was a lot, way different ballgame than what we have today. And so the Barbie lyrics, even though they're not as explicit as some of the songs like the Ariana Grande songs or the Blueberry Faygo song, which has a lot of like references to guns and drugs and stuff like that. And I love that song, don't get me wrong, and I listen to it all the time. But the point is that, what do you do, if a song refers to your product, right, that you've invested so much in, and but maybe it's a different image. And usually it's a real big problem because I love Drake and all these other musicians. They're always singing about Bentleys and G6s, all these high-end luxury goods. So you are one of these private companies owns one of these high-end luxury goods, Gucci. You could take one of two strategies. Hey, this is great. You got Drake repping my brand for free, helping to create consumer demand. Or you can do what Mattel did and say, oh, hell no, you're not going to control the way I market my brand. Now, what's interesting is the trial court ends up dismissing the case. But in the synopsis, what's really interesting is that Mattel did in chess, we'd call this a fork. A fork is one of the most powerful moves you can make in chess, Not the most powerful, but it's one of them. A fork is basically when you position a piece in such a way that it can capture two or more of another piece of the other side. So basically, the other side is going to lose a piece no matter what they do, And so and you see this in law. You see this with the Winklevoss lawsuit. You saw it's not just theft of an idea, misappropriation of trade secret. They throw in breach of contract. They throw in fraud. They even throw in unjust enrichment, and they throw in probably the most strongest argument, the breach of fiduciary duty that we talked about. Well, here Mattel does the same thing. They're going to sue for trademark infringement, right? Because Barbie is a registered trademark, and they're also going to throw in a copyright infringement claim, because guess what? Barbie, the design of Barbie, the packaging of Barbie, that shade of pink, the Barbie packaging, all that stuff is not only trademarked, Mattel has gone to the time and trouble to copyright that as well, So it's, so here's the thing. So we have a two-pronged attack, hoping to win. Then the trial court says, they're going to dismiss the case, but Mattel is going to appeal up to the Court of Appeals. And the question is, what should the court do? What is the right decision? Did the trial court, and here what I want to say before we just jumped into this, and this is the important thing of this case. It's two different legal standards or two different legal tests that courts, again, going all the way back to the common law, have adopted to determine whether there's trademark infringement or whether there's copyright infringement. With copyright infringement, we'd actually have to look at the video, because in that we'd have to see, okay, with copyright infringement, why the standard is a clear-cut rule. It's a clear-cut rule. There's got to be an actual copying, of whatever is copyrighted, like the color pink or, the Barbie logo, the Barbie doll itself. With trademark infringement, the standard is a lot more flexible. The standard is going to be substantial similarity test. So it doesn't have to be an identical, like you don't have to use here they do use the word Barbie. And there's, I think, one of the singers, and there's one of the other guys plays Ken. So it's substantial similarity test. You know what I mean? To me, the judge at the lower court should have allowed this case to go to a jury and decide whether, at least on the trademark claim, there's a substantial similarity. Also on the 4-factor test for fair use, copyright claim, that fair use, that's a legal test. So the court will always decide that. But how can this be fair use when you're using the actual word Barbie? It's not like you're saying, I'm maybe girly doll or some other word, and you're kind of insinuating Barbie, you're actually using the word Barbie. So how can that be fair use? What should the appellate court do here? Anybody want to jump in here, maybe argue Mattel's side, or do you think the trial court got it right, by dismissing this case? Look, there's no infringement here. No infringement here. But by the way, this is a huge case, important, not just on its own merits, because of the Barbie doll, which is such an important product and part of our culture, not just because of the relationship between intellectual property and general culture, but also because think of our daily lives, right? I know for a fact, like a lot of fraternities and sororities, right? They'll print out like T-shirts to celebrate a party or an event using someone's logo. I remember when I visited Yale, as for their recruitment weekend for admitted students. I remember they had a picture of the Yale Law School, which is a beautiful old building, and it had the slogan, "Just do it." So it's clear trademark infringement, you know what I mean? And copyright to the extent those marks are copyrighted. So we all incorporate in our daily, speech, and sometimes, in our drawings and stuff like that we share with each other. So this is an important case, how much can we use of a trademark or a copyright? Anybody want to argue either of the two sides? Either for the trial court judge didn't buy Mattel's argument, you know what I mean? But this is now going up on appeal, because Mattel has the firepower and the money, although so does MCA Records. Anybody thinks the trial court got it, correct, or would like to disagree with the trial court? This is what should, maybe we do the fair use first, you know what I mean? The four factors here. How is this fair use? How is this fair use? What would be the argument? There's four factors here, you know what I mean? Does it, remember the first factor is, what is the purpose, right? What is the purpose? The other factor is, the nature of the work that you're copying, Third factor is the amount of the work that you're copying, and the fourth factor is the impact on the market, for the copyrighted work. Here this is one of the difficult things with the four-factor test. I think two of the factors maybe go in the direction of Mattel. Maybe two of the factors go in the direction of MCA Records. The factor of like the purpose, why are they mentioning that one is a close one. You could say it's transformative in that they're taking this Barbie, that has this long and storied history, and converting her into just, okay, let's do a party Barbie version now, along with all these other Barbies that are out there. Maybe you could argue it's not news reporting. There's nothing educational necessarily about this. Maybe it's a parody. Maybe it's a parody. I think ultimately, it's what the trial court went with, the parody. But if you look at the other factors, they're using the word Barbie, right? And unapologetically, and they're doing it multiple times. It's the title of the song. It's the title of the song, And so there, when it comes to the nature, and then the nature of the copy of the work, it's completely commercial. It's Mattel's #1 bestseller. So those two factors seem to go in Mattel's direction, this is a commercial product, even though we're redesigning Barbie to make her more like a doctor, an astronaut, a baseball player, doing all these things that she can do, not just be a pretty model, but she can do all these things that require brains. So it's like, it's a commercial product. We make money off this product, and they're using the word Barbie, not just in the song, but in the title of their song, and in the video and all that, they're recreating a Barbie world, So it seems to be those factors. Then we go to the decisive factor. I'm personally assuming that the Aqua song, because it was very popular and it is very catchy, I'm assuming it helped expand the sales of Barbie dolls, you know what I mean? Regardless of the effect it had on the Barbie image. But my assumption could be incorrect, right? That would require empirical data, right? That would require, let's call an economist to testify. Let's call somebody, with the background that can measure sales. Let's call, Mattel, executives, tell us, what were your sales? You know what I'm saying? And now, by the way, this is why statistics and data analysis is so important. This is just a footnote, right? Because you could measure sales in terms of number of Barbie dolls sold, revenues, right? Merchandising rights, because Barbie has deals like with McDonald's, for Happy Meals, and the movies that these Barbie Nani referred to it. My daughter has watched those when she was younger. Most of them are horrible, by the way. It's just, I can't believe it. They're pretty mindless. But some are better than others. The point is, some of those are not made in-house by Mattel. They're just, they license the rights to a movie producer, and then the movie studio will do the Barbie. But anyways, that's an empirical question, so that could go either way. If my assumption is correct that Mattel sales increased, because of the song, then, what do you do when you have two of the factors going in one direction and two of the factors going in the other direction, right? What do you do when there's a tie, right? So it's like, here I will tell you, both the trial court and the appellate court both dismissed the copyright infringement claim. The other thing is, what about the trademark infringement? Remember, trademark infringement, all I have to do is show a substantial similarity. You know what I mean? With copyright, I really have two defenses. One would be fair use. The other would be, there's no real copying here, except for I am using the word Barbie, but, I'm not using the Barbie logo. It's the logo that's copyrighted, not the word, right? Now, the word is trademarked. That's true, right? The use of the word Barbie to describe a doll is either suggestive or arbitrary and fanciful. At the very least, it has a secondary meaning. When you hear the word Barbie, the first thing you probably think about is going to be the Barbie doll, right? To which Mattel owns the rights. So trademark infringement looks like a stronger claim here. What should the court do? And I will tell you, by the way, after this case, Congress enacted, in large part because of this case, something called the Trademark Dilution Act. And the Trademark Dilution Act, let me tell you here, Mattel would have won automatically under the Trademark Dilution Act, because the Trademark Dilution Act, it only applies to so-called famous marks, marks that are really worldwide famous kind of thing. And there, if your mark is classified as a famous mark by the courts, you don't have to prove substantial similarity. You're allowed to come in. And in fact, in the next class, I'll share with you a famous case with Starbucks, involving Starbucks, involving the Trademark Dilution Act. But for now, let's talk about the traditional common law and federal law as is incorporated in the trademark law, Lanham Act, the so-called substantial similarity test. You look at the video, right? It's not exact copy. That model doesn't look like identical to Barbie, but it's a substantial similarity test, right? So how can the appellate court not rule for Mattel, basically? One of the ironies here is, anybody want to jump in? Anybody have any thoughts about the substantial similarity test? Yeah.
Does it include like software? Because I know that there was this conspiracy, or I don't know if it's a known fact, but that like sometimes Samsung adopts some of the, not Samsung, Apple adopts some of the Samsung features and things like that. So like, how does that work?
Excellent question. And you can see in our system of stare decisis, that's the other reason why this case is important, because a lot of like Apple, like we said in our very first module D, Law of Ideas class, that's how companies and entrepreneurs become successful. It's by using intellectual property law, trademarking their brands, copywriting their logos, and either via trade secret or patent law, protecting their ideas, right? And so computer code, which takes us back to the founding of Facebook, right? Takes us back to the internet age, right? Or it takes us now forward to the internet age, right? A lot of times with computer code, source code, right? And remember, source code, and I believe in the module, I included, somebody posted on GitHub what they called vintage Facebook source code from 2005. And so, a lot of this, of course, has now been modified as Facebook has really evolved and changed over the years. But the point is that, with source code, which is just basically, any computer programming language is just a set of instructions for computers to follow. And so there are different languages like Python and JavaScript, C++, all these different computer programming languages. But what they all have in common is they're ways of giving computers a set of instructions. By the way, Apple in this was completely innovative and ahead of their time, because what Apple did is, let's create a computer product, personal computing product, where you don't need to have to know how to code in order to use the functionality of a computer. Let's do the coding ourselves and make it, the interface, easy for people to use. So a lot of things that we take for granted, which is the mouse and the point and click technology and stuff like that, a lot of that stuff was pioneered or either pioneered by Apple or improved by Apple, like the mouse. The mouse was actually IBM engineers came up with that, but Apple made it very simple and easy to use. So anyways, with computer programs, you can either do a trade secret with source code and say, okay, you know what I mean? Let me get my computer programmers to sign a non-disclosure agreement, or we can just copyright. And by the way, what's really cool about the Winklevoss lawsuit, which I did not mention, is after a month after they filed their complaint in federal court in Boston, they decided, on the advice of their lawyer, they decided, let's go to the Library in Congress, let's file all that source code that Mark Zuckerberg did write before, before he declared that the site was not functional. Let me go ahead and the Winklevoss twins and their partner Divya Narendra, let's go ahead and copyright. Very easy to do, just file a form, go to the Library of Congress, you can mail it in. Now you can do it online as well. Let's copyright our source code, and then let's amend our complaint to add a copyright infringement claim, in addition to all of the common law claims that we've already discussed in the class. So, and we'll talk more about copyright infringement in a different class. I'll say more about that. But let me say here before I forget, I do want to say a further footnote. That issue actually went on appeal, because then Mark Zuckerberg's lawyers, when they were ready to file their motion to dismiss, what they ended up arguing was, you know what? You didn't register your copyright. You didn't copyright your source code until after you brought the lawsuit, until after the facts that occurred in this case. It's not like you copyrighted your source code and then Zuckerberg stole it, right? Or allegedly, right? No, you basically make the allegation that he stole the source code as it was, allegedly a trade secret. But your lawyer realizes, wait a minute, what are the reasonable steps here? The judge is going to want to see some non-disclosure agreements, going to want to see some evidence of the steps that were taken to keep the idea a secret. So in absence of that, let me copyright the source code, right? And then, but it was done after all of this occurred. And so the case actually went up all the way to the First Circuit Court of Appeals. And in fact, I didn't know it at the time, but at the time I was I was a law professor at the time, but I also, and I continue to consult and practice law in cases that interest me, cases that involve the public interest. And one case that interested me involving a tax case out of the Commonwealth of Puerto Rico, it was argued all the way before a panel of the First Circuit Court of Appeals in Boston. And it was the same panel that would go on and decide the appeal of can the Winklevoss twins bring this amended complaint with this copyright claim that was not, the copyright not being registered until after. I'll discuss that later. Here, let me just say what happened in this case, in the Mattel case. In the Mattel case, as we saw, the trial court dismissed both of the claims, and the appellate court, again, although this was in the Ninth Circuit, so it was out in California, the appellate court also basically affirmed the decision of the trial judge to dismiss both of the claims. And they dismissed the copyright claim on fair use grounds, that it was a parody, and the Ninth Circuit Court of Appeals also dismissed the trademark claim. And I'll read you some language from the court's opinion. Here they said that basically they applied something called the literary title rule. And they said, we conclude that MCA Records' use of Barbie in the title of the song is not an infringement of Mattel's trademark. The use of Barbie in the song title clearly is relevant to the underlying work, namely the song itself. The song title does not explicitly mislead as to the source of the work. It does not explicitly or otherwise suggest that it was produced by Mattel. So here, this literary, this is, if you will, this literary title rule that the court used, is important, right? Because this means that you can now, if you write a poem or a short story, it's okay then to refer to a trademark or copyrighted product or brand, whatever. So it's actually a very important case. But notice what the court is saying there, as long as you don't try to mislead consumers, right? As long as it's clear that, you have nothing to do with Mattel. You have nothing to do with the real Barbie, And here I would argue that, at least to young children, maybe adults are able to discern, but because Barbies are mostly marketed to young girls, to me, I don't know if the appellate court got it right, or the trial court, personally, to me, I would make more of a deal that, here the relevant audience needs to be young girls. And how are young girls not to know that the song has nothing to do with Mattel? You know what I mean? And the MCA record, all that. Because when you're a kid, you don't, unless you're a real smart kid, you're not really thinking of all those technical things. So I just want to throw that out there that, although MCA Records won the case, I thought Mattel had a very strong argument to be made. And all right. So with that, let's go ahead and conclude. As I promised, I would end this class a little bit early, but I will end the recording as well. Let's see here.